should you set up a revocable living trust? In this video, I'm going to share with you what a living trust is, how it works, and the benefits. After watching this video, you'll know if a revocable living trust is right or wrong for you, and you'll learn how to save your family thousands of dollars in legal fees. Hi, I'm Pamela Moss Garrett. I'm a lawyer and the founder of Law Mother, and this channel helps parents with money and legal tips to provide a lasting legacy. Let's dive into Living Trust 101. In order to understand revocable living trusts, also known as RLTs, living trusts, you need to understand first what happens to your assets when you die or become incapacitated without a trust. When you die or if you become incapacitated, one of three things will happen. 1, you die without a plan. 2, you die with a will. And 3, you die with a trust and a pour-over will. First, if you have no plan, your assets will go through probate. Probate court is the process where a stranger, a judge, decides what happens to your assets and your minor children if you have them. Now, the judge will follow the laws of the state you live in when you pass away or own real estate in. So if you own property in multiple states, listen up, every state will have its own probate case. For example, if you own property in Florida and Colorado and you die without a plan, when you die, your family will have to go through probate court in both of those states. Probate is often described as a lawsuit against yourself for the benefit of your creditors. Sounds bad, right? It is. The disadvantages of probate are 1, the cost, 2, the time, 3, the government is in control, and 4, it's public. Probate is costly. AARP found that on average 5 to 10% of an estate is eaten up by probate costs, and that smaller estates suffer a proportionally higher probate cost than larger estates. They estimate 20% of estate value. Probate is time consuming, and time is very valuable for your loved ones. Your assets are frozen. Your loved ones are in the court's timetable until they can get access. On average, that can take 9 months to 2 years. I've heard horror stories, though, about 3 and even 6-year probate proceedings. The people that go through these complain that dealing with the probate and lawyers is so stressful and really felt like a full-time job. Probate is public, so it becomes a public record who is inheriting what, which can make your loved ones more vulnerable to scammers and predators. Now, the second option is you die with a will, and a will guarantees probate. We just went over all the disadvantages of probate, so why are lawyers recommending wills? I wonder, who makes money in court cases? Lawyers. That same AARP study said lawyers should be required to tell clients how much they would charge for probate when they recommend a will. Wills are often loss leaders for many law firms that make more money on probate, so be extra cautious if a lawyer is recommending a will and ask what they charge for probate. Often these lawyers are recommending a $1,000 will because they know they'll eventually get $50,000 to $100,000 in probate. Now, there are many good lawyers out there recommending wills, so they aren't all ill-intentioned, but some of them just don't know better. They were taught to do this by someone else and never questioned it, or estate planning isn't their specialty. Just like when you go to a specialist for heart surgery, lawyers also specialize. So you want to work with a lawyer who focuses on estate planning. So what about small estates? Well, it depends. Some states have streamlined processes if you have less than a threshold of assets, for example, less than $75,000 in assets. If you are in one of those states, a will may be an okay option. But remember, probate avoidance isn't the only benefit of a trust. With a trust, there are more options to protect the assets for your kids. Now, the third option is you die with a living trust and a pour-over will. Now, that same AARP study concluded that living trusts are better than wills. And in my experience as a lawyer with over 13 years of experience, I agree. If a living trust is drafted correctly, meaning written up correctly, and it's funded correctly, meaning the assets are put in the trust, it will avoid probate. And with a trust, you can include asset protection language to create a lasting legacy. Now, you are going to want to stick around to the last part of this video because I'm going to explain more about asset protection, and it will make a huge difference for your family. But first, how does a trust work? Well, a revocable living trust is a legal document, and you set it up in life and you are in control. It's revocable, meaning you can change it, and you can take things in and out of it throughout the rest of your life. You can also change the terms of it. If you are married, you can do a joint trust, or you can do separate trusts. You'll often hear a revocable living trust called just a trust, a living trust, an RLT, and these are all denoting the same thing. How you put things in a trust is called funding the trust. For example, your primary residence will be titled in the trust. And often a pour-over will is combined with a trust, and a pour-over will is created with the hopes it never has to be used. A pour-over will state that if any assets are outside of your trust when you die, it will go into your trust. It's designed as a safety measure. We don't want to rely on it because those assets would have to go through probate, but it's there to protect you. Now, some myths I often hear that keep people from setting up trusts are first, that trusts are only for multimillionaires. And that's not true. There's no threshold of wealth you need for a trust. I've created trusts for a client who worked at Walmart, and I've also created trusts for clients who own multi-million-dollar businesses. It's not about how much you have, it's about the experience you want your loved ones to go through when you die or become incapacitated. And it's about control. Do you want to be in control, or do you want the government to be in control? A second myth is trusts are more expensive than wills, and AARP concluded that's not the case. Sometimes you need to spend money to save money, and that's the case with trusts. Trusts are more expensive to set up than a will, but in the long term, they save more money for your family. Spend a little more now to make it much easier and save more money for your loved ones in the long run. A third myth is I don't need a trust. All my beneficiaries are adults. I can use transfer on deaths. First, transfer on deaths aren't triggered if you become incapacitated because you're not dead. So you have no incapacity protection. And if you become incapacitated, your loved ones have to go through probate. And we just went through all the reasons you don't want them to go through that. But more importantly, transfers on death don't allow you to put in place asset protection and create a lasting legacy. So let's dive into the asset protection benefits of a trust and how you can create a lasting legacy for your spouse and kids. So you're going to want to stick around to the end because this is going to make a huge difference for your loved ones. First, the asset protection benefits of having a trust for your spouse is a trust can be designed to minimize or eliminate paying estate taxes when the first of you dies. Now, the current federal estate tax rate is 40% if you're over a certain threshold. And no one knows what that federal estate tax threshold is going to be when you die. For many years, that threshold was 1 million, then it went up to 2 million, and at the time of this recording, that threshold is 12 million, but it's set to sunset to 6 million in 2026, and they may change it before that. Federal estate tax, also known as death tax, is a moving target. So if you want to eliminate or minimize paying that tax, you need to put in place a trust-based estate planning. Additionally, some states even have state estate taxes, and if you're in one of those states, it's important to work with a lawyer in that state to minimize those taxes. A trust can also be designed to provide the surviving spouse protection from future divorces and future creditors. Now let's talk about the asset protection benefits for your kids. Now, if you have children, whether they are minors, adults, special needs, or if you have a blended family, you can design your revocable living trust to flow to a lifetime asset protection trust for your kids, which gives them many benefits. First, you can protect your kids from future divorces, creditors, and lawsuits. So say, for example, your kid inherits $1 million from you and then gets divorced or gets in a car crash or gets sued. If you utilize the Lifetime Asset Protection Trust, their inheritance is fully protected. And no, a prenup isn't enough. Prenuptial agreements can be pierced in many states, and prenups don't protect the growth of the asset during the marriage. Now let's talk about the lasting legacy and generational wealth. Very few kids make good decisions when they get large sums of cash, so you can put in place things to give your kids guidance on using the money. You can also spread out the funds over ages and stages, and also have someone serve as co-trustee to give them guidance. These trusts can be dynasty trusts, so if you set it up correctly, it will carry on for generations. You can also give guidance on how the money should be spent to be aligned with your values. For example, for the money to be used on certain educational expenses or investments or charities. And if you have a special needs beneficiary, you can even build in a special needs trust. We went through a lot of information in a short period of time. If you have questions, please comment and subscribe. I'll be using these comments to create new helpful content. I'll also be listing free resources below. If you know someone who needs this information, it's easy, just forward them this video.